Thank you. So here is Eric, lawyer. And Eric, thank you so much for coming all this way and joining us. We really, really appreciate having you.
Great. Thank you so much for that introduction, and just want to thank you all for inviting me here today. It truly is an honor and privilege to be able to speak to this organization. The League of Women Voters has been so vital to the expansion of voter rights, not just for women, but for all citizens in the United States for over a century, and I know it's a fight that continues to this day. Also want to thank all the organizers who invited me and who kind of helped me get ready for this event, and also my other speaker, Margaret Long, who will provide a vital perspective of both, what it is on the ground to be both a charter county and general law county. My goal for this presentation is to give both a general overview of the state and county relationship as defined under our Constitution and statute, and then speak specifically to the question of charter counties, both in the powers that they provide counties and the limits on what they don't. I think I have the right clicker here. Wrong clicker, there we go. Okay, so with that, I'll go ahead and get started. So I'll just cover this very quickly in case anybody is not familiar with CSAC. It's the California State Association of Counties. We represent all 58 counties in the state. It is a member organization with dues-paying members, so every county in our state is participated in CSAC. We've been around for a long time. I think this is our 129th year. I'm hoping I got the math right on that. We do a lot. We advocate on behalf of county government in front of the legislature and federal government. That's what I do. I'm a legislative advocate at CSAC, which is just a polite word for lobbyist. Like Joanne mentioned, I cover elections, general government, revenue and taxation, economic development, and a few other issue areas. CSAC also provides educational opportunities and training for county leadership. That includes boards of supervisors, other elected officials, and just staff with a lot of responsibilities at the local level. We also educate the public about the vital role that county governments play in our state and local issues. So with that out of the way, I'll go ahead and get into the meat of my presentation. This map is pretty self-explanatory. It's a map of all of the counties in our state with the charter counties highlighted. You can see that there's pretty even geographic distribution of which counties have chosen to adopt a charter. And just to get some terminology out of the way, a county that has adopted a charter will be referred to as a charter county, and then counties that have not are referred to as general law counties. And that's because due to the absence of a charter, they abide under general laws of the state and our Constitution. There's a star here for Shasta County because I'm here tonight, and it's the only county currently with a charter, currently being considered by its voters. This is another just summary table depicting the landscape of which counties have chosen to adopt a charter. You might notice a few trends. One is that by and large, the largest and most populated counties have adopted a charter, but you might also notice plenty of smaller rural counties have adopted charters as well. I think maybe what's most interesting about this slide is you may notice that by and large, aside from 4 counties, every county that has adopted a charter did so by 1933. That's due to a number of factors. There's not necessarily one specific change in state law that precipitated that per se, but over the decades, statute has been changed through initiative and through statutory changes that have essentially given counties a lot of the powers and independence that previously belonged only to charter counties. And for that reason, fewer and fewer counties have chosen to adopt a charter. We've seen a few considerations of counties that have considered whether or not they want to adopt a charter. A colleague of mine gave a similar presentation to the San Benito Board of Supervisors in 2020. They ultimately decided not to pursue a charter. And then we gave a very similar presentation to the one I'm giving you now to the Shasta County Board of Supervisors in September of last year when they were initially considering a charter and had some questions about what a charter means for county government. This slide has a lot on it, and I'm going to get into the details of each of these sections. It lays out some of the key principles in our Constitution that really speak to the powers of both counties and the powers specifically of charter counties. I think what's an important place to start this presentation is really that that first section, section 1 of Article 11 of the Constitution, which begins with noting that the state is divided into counties and defining counties as legal subdivisions of the state. So what does that mean? I think the easiest way to crystallize the difference between powers given to counties versus the state versus cities is to think about the reality that the state is really composed of the counties. It's not composed of the cities. Every single individual who lives in a county lives in the state. Everybody who lives in the state lives in the county. It's not true of cities. And because of that, counties effectively are prescribed a lot of the rules that the state, the powers that the state holds. Cities have a little bit more discretion and leeway in terms of how they want to decide their own home rule. I'm going to get into a lot more of the details about that through the course of my presentation, but just wanted to start with that framing. I think actually the best way to envision the real differences in what charter counties do not provide is to look at the additional powers that a charter city provides. But first I'll go through each of the some sections of the Constitution. So you can see Article 11, Section 3 provides counties and cities some power to both adopt, revise, and amend or repeal the charter. On its face, the powers given to a charter county seem awfully broad, allowing charters to supersede inconsistent state laws. However, all additional powers and limitations rest on that crucial language, where allowed. So what the Constitution basically says is that a county can, through a charter, supersede state laws, but only in ways that the Constitution already provides. So there's very few instances where a charter county can go above and beyond what's permitted in our Constitution or in statute. Next, Section 4 provides some of the provisions that can and that must be included in a charter. This essentially says that anytime a county adopts a charter, it has to, at the very least, speak to a number of provisions, including the number of elected Board of Supervisor members. A charter, one of the few areas that charters give counties extra authority is actually granting them the ability to elect more than 5 county supervisors. A charter gives counties the authority to choose additional representation. To my knowledge, no county has actually done that aside from the city and county of San Francisco, and the fact that it's both a city and a county and that it's San Francisco. I don't know that it's actually a good analogy to make for counties writ large. The Constitution does say too that each county must have at a minimum an elected sheriff, an elected DA, and an elected assessor. Charters under our Constitution are supposed to also speak to the compensation terms and removal of officials, performance of functions, and are supposed to speak to the powers and duties of officers. One of the areas that charters typically opine on is both the consolidation and segregation of duties. And what I mean by that is, some counties have a treasurer tax collector, some counties have a treasurer and a tax collector in different offices, different individuals. Charters are typically supposed to speak to that, but that doesn't mean they have to. So Orange County in 2002 essentially tested our Constitution. And while the Constitution prescribes a number of provisions that have to be in a charter, Orange County at that time adopted a charter that was kind of interesting. It was really just 2 sentences and just spoke to that county's ability to replace a vacant board position, either through Board of Supervisors or through a special election. It essentially tested what's in the Constitution, and what the Attorney General at the time found and future court cases determined is that while that charter did not speak to every provision that the Constitution says a charter should, the absence of that language essentially says that that county defers to general law. They essentially permitted a single issue charter to be adopted by a county, and I understand that that's the type of charter that's being considered right now in Shasta County. And then these sections of government code I think are important to highlight. So I spoke a little bit earlier about how over the decades statute has changed in ways that perhaps reduce the need for counties to adopt a charter. One of those is by essentially saying that even non-charter counties, general law counties, can, through local ordinance, adjust which positions are electable and appointive. They cannot, whether you're a charter county or a general law county, you must, at the very minimum, elect a sheriff, a DA, an assessor, and a board of supervisors. But absent that, are not required to have electable positions for any of the other offices. But what is important is to note and to clarify that anytime a charter is changed or a local initiative changes an elected position, it both has to be approved by voters. And what our statute says is that if any time an elected position is converted to appointed, that the person who holds that office is required to be allowed to finish out the term to which they were elected. So just wanted to clarify that. There's sections too in statute that essentially prescribe what positions can be hybridized, hyphenated. So you can have a county can choose for itself to elect, say a county clerk recorder, a treasurer tax collector, or auditor controller. You can't have, a treasurer coroner per se. The statute doesn't allow that. There's a lot of combinations they don't allow, but there's actually a section in our law that lays out every single combination of offices that the electors can choose, either through a charter or through a local ordinance. So I spoke to this a little bit earlier, and I think that this is an important distinction to make because you all may have encountered this. I certainly have. There's a lot of confusion about what it means to be a charter county. Some folks might read what's in the Constitution and assume that because it speaks to county charters allowing counties to supersede inconsistent state laws, that it grants counties this autonomy and ability to adopt ordinances that are in conflict with state laws. And what has been found, over and over again through court cases is that's simply not the case. This court case, Dibb versus County of San Diego, I think spoke very clearly to the difference between the powers and independence provided to charter cities versus charter counties, and just very clearly declared that charter counties are still required to perform the same functions required of all counties under general law. Charter cities, they are different, and there's constant tests of that independence that charter cities can have to say, do revenue raising changes to their charter that maybe aren't allowed by statute. So again, I'm going to highlight some of the sections of both our Constitution and then some court cases and other language that speaks to the powers that the counties have under our state. I mentioned earlier that counties are legal subdivisions of the state of California, and that that may be obvious to a lot of folks here. I think it's just important to remember that the power and independence that counties have, it's due to decisions made at the state level to grant those powers to the counties, and the state really at any time, to my own frustration in representing counties before the legislature, can pull back some of those powers from counties themselves. So, charters really just speak to the ability for counties to determine for themselves their own home rule and governance and how their elected officials are elected, their term limits and that kind of thing. Not necessarily giving them the ability to ignore state labor laws or regulations or that kind of thing. And I think too that our Constitution is actually fairly clear about the limits of charter county powers. You can see here in the bold language, charter counties can control the structure of their government, but only within the parameters of the California Constitution. So, while charter counties do have some limited powers to, ignore statute under their own constitutional authority, those powers are limited because, again, a county is a legal political subdivision of the state of California. So, I've kind of been speaking a little bit abstract about what our Constitution says and about what counties can and can't do, but I think what really helps is just to bring it down to the tangible level of what these charters typically speak to. So often they will speak to compensation and term limits. There was an interesting example in San Bernardino County in 2020 where voters chose to amend their county charter to impose 4-year term limits on their board of supervisors and to cap their compensation at, I believe, $5,000 a month. Clearly very unpopular with the supervisors. That, I believe, was reversed back again in an election a couple years later. Another item that charters are allowed to speak to, but I think this is actually a bit moot. I'm not an election attorney, so grain of salt. But a charter does give counties the authority to choose a few different options on how they conduct local elections, including at-large, or what's called at-large from a district. Essentially, that means that each board of supervisor has to come from the district they represent, but every single member of the county votes on who gets elected. That's that, and the at-large elections. I believe there's questions under the Voting Rights Act of whether or not they would be permissible under the U.S. Constitution. So, and I'm not aware of any county that has chosen to experiment with either of those election models, but it is something that is actually spoken to in our state laws. And then I think what's most relevant to this group is that a charter can speak to replacement of vacant board positions, and I understand that is the interest that the Shasta County Board of Supervisors has in adopting a charter, and at the very least that is the decision before voters in Shasta County coming up here in just about 5 or 6 weeks. So again, this is yet another slide on the limitations on authority that charter counties have. So just to be clear, county charters do not provide any additional authority to ignore regulations, revenue-raising abilities. Specifically, if you think about Prop 13, all the voter thresholds that are necessary to change property taxes, sales taxes, that kind of thing. Special taxes. A charter does not allow counties to ignore what's in our Constitution and what's in our statute. So this slide again speaks to the charter currently being considered by voters in Shasta County. A point that I want to make and I want to emphasize, again and again, is that either under a charter or a general law county, anytime these governance decisions are considered by voters, whether it would be to take an elected position to be appointed, or simply to adopt, amend, revise a charter, it has to be approved by voters, and that is consistent with any change to a charter. It has to be approved by a majority of voters. There's a number of ways that changes to a charter can be implemented. It can come from Board of Supervisors, or it can come through initiative, through a charter commission. I have a couple of slides on that coming up. But I think it's important to note and to be consistent in saying that any change has to be approved by a majority of voters. So again, these next couple of slides speak to the process for adopting a charter. Just spoke to this. Board of Supervisors by majority vote can place a charter on the ballot. Has to get approved by a majority of voters, or there's a process to form, among a county's residents, a charter commission, and that's prescribed under state law, which can be a little bit complicated, but it's definitely an option for local citizens. That concludes my report, and I don't know if we're going to take questions now or wait until Margaret completes her presentation, but go ahead and
wait for Margaret.
I think that makes sense. Okay. Appreciate it. Thank you. Thank you for your time.
Sure, I'll talk while we get her presentation set up. So I'm talking while we get her presentation set up. that was good information for us, because Measure D is an important ballot measure for us coming up. And I think that a lot of people don't understand in Measure D that we're not voting for a charter county. We're voting for a charter county with a specific privilege. I'll call it a privilege, where you can do this particular thing to replace your own supervisors. I should note that I did a little bit of research, and I discovered that the governor hasn't actually been very good about replacing supervisors when they leave. So there are some counties who have been without a fifth supervisor for 2 years or more. I think that's kind of an interesting little factoid just for you. And with that, I'm going to introduce Margaret. Margaret Long is a founding member of the Prentice Long PC and its managing partner. Ms. Long's practice includes municipal law, civil litigation, labor and employment law, and business law. Ms. Long has considerable experience in advising municipalities and public agencies on issues relating to employment, labor, public nuisance, law enforcement, land use, code enforcement, eminent domain, housing, public contracting, unlawful detainer, medical marijuana abatement, Proposition 218, and the Brown Act. The Brown Act is one of the favorite things of the League of Women Voters, I should point out. Her expertise includes facilitating local elections and initiatives and engaging in labor negotiations on behalf of the local entity. She also has experience in providing advice to planning commissions, water districts, community service districts, municipal airports, and transportation authorities. Ms. Long provides training to public and private entities on a wide variety of topics, including sexual harassment, ethics, employment matters, governance, and legal updates. She is currently the county counsel in Tehama, Modoc, and Trinity County, and the city attorney for the cities of Susanville and Fort Jones. And I'm sure we're going to learn a little bit more about her. Thank you, Margaret, for joining us tonight.
Thank you for having me. I've been given very specific instructions to only talk to this side of the room, so I apologize in advance for those on the wrong side of the room. And I think Eric did such a good introduction, I don't think I can beat it. So I agree with everyone he thanked, and I'd also like to add in a few more things. I want to thank the wonderful woman who told me my jacket was inside out when I got here. I also want to thank whoever made that split pea soup. It was fantastic. So thank you very much for having us. Okay, so I would like to, before we get into the meat, which I know there's going to be a lot of questions on Tehama County, one of the counties I'm county counsel in, and some questions probably on what's going on with the Shasta County ballot, and I'm happy to provide my opinion as my legal opinion as a county counsel. I don't have a political opinion on it because, again, my job as county counsel is not to provide political opinions. It's to provide neutral analysis from a legal perspective. I know there has been a lot of questions right now about what a county council is. I know Shasta County Council has been in the news a lot lately because they have been through quite a few, and there's been somewhat of a question of what we do. And so I just wanted to make sure, kind of to start off by letting you know what we do. So as a county council, I'm the top legal advisor on civil matters for the jurisdiction. I have to supervise and provide information to the Board of Supervisors and department heads on all civil issues within the county jurisdiction. I report directly to the board. One of the positions that is appointed by the board. I don't have any other bosses but those 5. And I don't represent any individual board members. In fact, I'm not allowed to give personal advice to any board members or talk to them specifically about whatever their issues are. I have to look at the county as a whole and do what I believe in my best interest is in the best interest of the county. And as a result, that's why one of the provisions that applies to county councils is that we're given 4-year terms. The reason we were given 4-year terms is because we have to have the freedom to give the right answer, not the popular answer. And so what I'm finding a lot is that one of the provisions of charter counties is that you can limit the term of your county council. And I've had some conversations with my colleagues who are in charter counties who are just at will, and they say they a lot of times spend a lot of time trying to figure out how they're not to lose their job and still give the right answer. So I'm very fortunate that I don't have that. I just give the right answer and let the chips fall where they may. And again, I'm also a politically neutral position. I always say that if my board members come to me and ask me, how do I paint every house in this county red? I look at zoning ordinances, I look at regulations, and I figure out how to paint it red. And if I'm lucky, they help me pick the shade of red. But other than that, it's really, I do what they say. I work in Modoc County, very conservative county, has no cannabis. I work in Trinity County, it's a grow county. So again, I take no position, I just help you do it legally. I always use the paint the town red conversation until in Trinity County they asked me to write an ordinance banning the hunting of Bigfoot. And so now I use that as my example of if you ask me to do it and it's legal, I'll help you. So the question that I know is going to come up, and I'm sure I'm going to get asked, is how do I feel about county charters? What's my perspective on that? And to ask that question is kind of like asking me, how do I feel about law? How do I feel about people? Some are good and some are bad. There's some provisions in charters that are good. There's some provisions in charters that are bad. And what is really important is how they are written and how they're put into place. And so again, as the county council, my job is not to say this is a great idea. This is to look at it and say, here are the unintended consequences or legal hurdles we're going to face if we are going to go through this process of becoming a charter county. One of the benefits of not being a charter county is, for better or worse, California law is pretty well vetted by the time it gets through, meaning they go through Ledge Council, they go through everybody under the sun gets a chance to make a comment on it. All the legal minds come and say, this is a good problem, this is not a problem. When small jurisdictions like the ones I work in decide they want to become a charter county, it's usually just me and someone else in the room trying to figure out if this is legal. And as a result, there are things that come out that aren't, again, unintentional consequences of bringing them forward. So again, what I'm going to try to do is kind of go through some of the unintentional consequences and show you how I would process both Tehama County's charter, which I live under every day, and then Shasta County's charter, and show you kind of areas that I would look at if I was the county council. So first, let's talk a little about Tehama County. So the questions, we got a couple of questions ahead of time, and one of the questions was, why did Tehama County become a charter county in 1916? And the answer is, I have no idea. I was actually there today, and I went over thinking I would go talk to the clerk of the board, who's also our election official and basically knows everything. She's our Kathy Darling, who just knows everything about everything. And I went over to her and I said, "Okay, tell me what happened." And she was like, "I don't have time for you. I don't know. We don't know." So I said, "Well, I'll make something up then." I said, "Maybe we'll say it's because of prohibition or something." And she said, "Fine, just say that." But what I really think, Eric gave the best explanation for it, is that back in the good old days in 1917 and 1916, this counties had a lot less control than they do now. And so this was a movement that was going into place for them to try to take back some of that control. Or not take back some of that control, get some of that control and make it localized. The Tehama County did that in 1916. And again, they lived under that until 1960, when the laws started becoming more county friendly. At that point, they had more strict laws than the state was providing them in some areas, and they thought, let's re-examine this. And so this is one of the few counties that actually did a charter commission, something that Eric explained. They actually brought in 14 people in who evaluated it and came up with it. And their recommendation, by and large, was to cut most of the charter out. Most of it wasn't really needed anymore. And so that happened in 1960. One of the things you also have to remember is that the charters are subject to constant litigation. You're creating law, which means the public can now come in and say the law is wrong, or ask a court to say the law is wrong. And that actually happened in Tehama County in 1975. A portion of it was deemed to be unconstitutional and was stricken from our charter. And so again, you don't see that very often. Eric made a reference to an Orange County case, which I'll talk a little bit more about, but it does happen. And so that's something we have to be very careful about. And that's, from an attorney's perspective, our worst nightmare. To put something in place, get the voters to vote on it, and all of a sudden find that it is not legal. So again, this is why we do this analysis up front. They have since then made 4 amendments to it. They set the salaries in 1984. They set the consolidated offices. So they put a lot of the positions together. The sheriff coroner, treasurer tax collector, public guardian became its own position. They did that in 2005. They were one of the counties that was an at-large county, meaning everybody in the county was eligible to run for every seat and everyone was able to vote on it. So you could have gotten 5 board members who lived in Red Bluff. That's the way it was until it changed, and now they do it by the district, same as other counties that we are talking about. Actually, I believe every other county we're talking about in the state of California. That only happened in 2008. So up until last year, I still had board members that were from the at-large days, and they remember the good old days when everyone could vote. And then the last one is they put into place an amendment regarding how to appoint supervisors, much like the Shasta County is doing. And since I've been county council, we've used it twice. So I have a little bit of experience how it came to play. But the one that Tehama County put in place is very different than what you're going to see with Shasta County, and I'll go through that a little bit. It's a very different ordinance because it has a lot of built-in protections. Where the Shasta County one is, this is what we do. Tehama County is a lot more, this is what happens, and if this doesn't happen, then this happens, and so we'll go through that a little bit. So Tehama County is one of the charter counties. So let's look at some of the provisions. They did what Eric spoke about. They put every provision in place that's required by code. So they have the limits of the terms, they have the consolidation of offices, they have all the good stuff in there. And they have 2 that we really, as county council and as employees of the county, we actually look at. And we see a lot and we deal with. And the first one is in section 2. And it says that our board members get paid $18,000 a year. That's it. And that was put in place in 1989. Doesn't put in consideration inflation. It doesn't put in consideration any of the other factors, such as cost of living, cost of housing. It just says you get paid $18,000 a year. And what happens if you want more? You have to take it back to the voters. And they've tried a couple times and it's never passed. You'll never, right now, what I'm seeing is you will not get a measure through to increase elected official salaries at this point in any county that I work in. It's just not popular. The public won't do it. So they're frozen at this amount, which, looking at the good side, we're never going to have a situation like Bell, California, where all of a sudden our elected officials are making $1 million a year. That's a good thing. The unintentional consequence is it dictates who can run for the board. Because on $18,000 a year, how many people can live on that? Very few. So you're going to get people who are retired and have retirement income, and that's it. That's it. Sometimes we get business owners who are able to run a business and do this, but being a supervisor is a full-time job. As much as folks wonder how many hours a day they're working a lot. They get phone calls after hours. They're working, and one time in Tehama County, I calculated the hourly rate that one of my supervisors got, and he made like $2.01 an hour based on the amount of hours he worked versus that rate. So it limits who we can get, and it really freezes it. I think I have one supervisor who is wonderful in Tehama County, and he's not running again this time. And I said, "Why aren't you running again?" He goes, "I'll be 90 years old when I'm done. It's time for me to take a break," and he deserves it. He's served with honor. But again, unintentional consequences. So what is there to do? A lot of jurisdictions that cap salaries in a charter put in provisions to have it increase based on CPI, or what is very popular is they put in there to have it increase based on what the judges receive. So the judges receive their salary from the state. So it's outside of the jurisdiction of the county. You can't argue that you're lobbying for yourself to get more money. You're looking at it and saying if third party, the state, decides to give the judges increase, we'll give you the proportional amount of increase. So that would be something that I would have recommended if I had been their county council in 1989 when I was 2 years old. No, I'm kidding. I wish I was that young. But so that's what I would have done there. So again, looking at the unintentional consequences, reading into the words is what really matters to me. The second one is the one we were just talking about, is what happens if a vacancy occurs. Now, I understand why this was put in place, and this one was put in place in recently, 2014, and I actually have spoken to the county council who now works for RCRC, which is a legislative agency, much like CSAC, but for rural communities. Talked to him about why he put it in there, and it's we want local control, we want fast reaction time to get somebody in there when we need them, and so they put together a provision that says if you have a vacancy, you will have 90 days to fill your vacancy. And if you fail to fill it in 19 days, the governor will fill your vacancy. So that's their option. That's what they came up with. And we've used it twice. First time was before my time, and it went fine. The second time, my board was a 2-2 deadlock. 2 people wanted one person, 2 people had the other. And we spent a lot of time in that boardroom waiting for them to figure it out. Ultimately, everybody had the same third choice person, and so the third choice person got it. Which, again, unintended consequence. Is it great that they were able to work it out and come to the third choice? Yes. Was it the one that was most qualified? I don't know. Again, I don't deal with policy. I was happy they came. But that doesn't always happen. When you're filling a vacancy, you're dealing with a 2-2 board. You're dealing with a non-majority board. So you're going to have to deal with that as a consequence. And they have it going to the governor. I know in the Shasta County one, it doesn't go to the governor. It goes to a special election. I have a ton of experience. I've been county council in Modoc County for 10 years, and about the same time in Trinity County. And actually, I'm sad to say, because of the turnover in county councils, I think I'm the longest serving county council in the state of California at this point. Someone say it's sad. I know. Sad for me as well. But I'm the longest. So I've dealt with this a lot. I dealt with these situations. I know Susan said her experience, or what she's noticing. My experience is, and I've been through many governors now, not just one, is that the governors are not eager to fill these positions. They typically, what we see is that they wait to the next election. And if they don't, it's usually at the request of the county, because they need somebody to fill this position. I'll talk for a second, but I had a county that got down to 3 supervisors, and that's a problem. You can't function with 3 supervisors. But by and large, if they do fill the position, and I've spoken to the governor's appointers on this many times, because unfortunately I was in Trinity County serving as the interim CAO for 2 years. This is where you always show up to meetings. I didn't show up to a meeting, and I got appointed CAO for 2 years. But we had the situation there where we needed somebody. We were working the governor, and the governor appointment group said to me, we look at 3 things. The first thing we look at is somebody who represents the community well. In Trinity County, they actually picked a grower, somebody who was a grower, because that was the big hot topics at the time. And man, was that an adventure for all of us. But it did happen. They looked at what the community wanted. The second thing they look is this person going to be electable? So I always hear, well, they're going to appoint a Democrat if they're a Democrat. And my experience is no, they appoint what the majority of the community is. They'll appoint to fit there, because they want their appointment to stay. Because they want to show they're serving the community. So they'll typically look at the demographics of the community and pick somebody as the same party preference as the majority of the community. And then the third thing they do is they actually will ask us. When I was CAO, the governor called my office and said, this is the person we're thinking of, what do you know? And again, at that time, I knew stuff. I'm an attorney, I've been to court, I know stuff. And so they take that into consideration. So Tama County appoints, if they can't fill it by themselves, they appoint through the governor. And by appointing through the governor, again, my experience is that the governor typically will wait. In Modoc County, the governor the governor never appointed. We went to election. In Alpine County, where I served for a period of time, it was 2.5 years. It was 2.5 years before they were appointed. So I don't have any fear that when there's a vacancy that it's going to be appointed. I sometimes have fear that we'll be operating with a 4-person board for 2 or 3 years. So that's just my perspective from Tama County. So again, Tama County has a lot more in there, but what I wanted to do is just kind of show you 2 of the sections and talk a little bit about how they're formed, why the words matter, and then look at it from that perspective. So let's talk about Measure D. Now, again, I have no opinion. Hopefully by the end of this, you'll have no idea how I'm going to vote for it as a Shasta County resident. You make your own decisions for yourself. All I'm going to do is tell you what I would have done if I was the county council, and what I assume their county council did. So again, remember, we give advice. They don't have to follow our advice. So, and a lot of times, I always get blamed for stuff, and I'm like, I don't advise them that. But of course, we can't say that because of attorney-client privilege, but we just give advice. So this is what I would have done if I had looked at Measure D. So it establishes Shasta County as a charter county. That's the basic concept of it. And it allows them to appoint or call for a special election to fill a supervisor. So let's look at the meat of the section. And I brought handouts that actually have it in there if you want to look with me, but or if you have amazing eyes and can read that, I'll be very, very impressed. I can't even read the one close to me. But the section that matters is it says Shasta County Board of Supervisors may fill the vacancy by appointment or call a special election. That's really the meat of it. So the concept is you may fill a vacancy or you may call a special election. So let me talk about what I would have said to my board if they had asked to do this. I would have said, okay, what happens if you have a 2-2 vote and you're in deadlock? What happens then? If you have a 2-2 vote, you can't even decide whether you're going to do an appointment or call for a special election. You're stuck. What happens? How long are you going to give yourself to decide this? On the Tama County, when they give themselves 90 days and then we're hit deadlock, it's going to the state. Here, could it go on for years? I don't know. It's not clear. So again, that's something I would have asked them to flesh out a little deeper. The other thing is, what happens if you lose 2 board members? And unfortunately, in Modoc County, that happened to us. We had one supervisor move out of district, and shortly after, another one of our long-term supervisors passed away. In county governance, we need majority vote to do most things, with the exception of a few, one of them being passing a budget adjustment. So if we want to change the budget, pay our bills, pay our staff, and we don't have enough money in our current allocated budget, we have to move it from other places. That requires a 4/5 vote. And it's a 4/5 vote of your governing body, meaning even if the seats aren't filled, you still need them, you still need the votes. So if you get down to 3 people, you can't move money around in the county until the next year. You're going to go into debt. So how does this contemplate if you get down to a 3-person board? Are you going to have a contingency in place when you're deadlocked? Again, questions I would have asked. How long would you be able to decide? So again, the words matter when you're looking at these types of initiatives, because again, concept, I understand it. It's what we do in Tehama, and frankly, I like it in Tehama. It's great, but you have to have your law written in a way that takes into consideration these unintentional consequences, and that's one of the things I would, as county council, have talked to them about. The other section I kind of keep coming back to is section 3. It's in the findings and declarations, and essentially it says that the board can propose a charter county, which they have, to be ratified by the electors during the next general election. Does anyone see a problem there? Yeah, we're in a primary election. March is not a general election. It's a primary election. So again, these are things that we would look at. Are you limiting beyond what you intend to limit? Maybe they intended to only be at a general election that you can make these changes. That's fine. But if they want it to be allowed at a non-general election, that language is going to prohibit that. And if the voters vote that in, then all of a sudden we're stuck with this until the voters vote it out, which again is very difficult to do. So that would be something I would have asked. I don't know what the answer would be. I don't know what my clients would have said. I don't know if we researched it and found out that was a void provision. Again, I'm not giving you an opinion. I'm just telling you what I would have looked at. And the last one, I'm kind of mad at Eric because he stole my thunder, but I will give it to him anyway. We are governed by the Constitution when we're dealing with charter counties. And the Constitution specifically says charter counties shall provide for, and then it lists exactly what we have to have in there. And as Eric pointed out, Shasta County is a 1-issue ballot measure. And so if this was my county, I would have gone back and done all of the research to find out, is this legal, is this not? And the answer is, yes, it is legal because of what happened in Orange County. They tried the same thing, and the courts ultimately rendered a decision that says, when you don't talk about it, when you just are silent on it, it diverts back to what the state regulations are. So I would agree with that. I think that is what the current law is. But what if that changes? What happens if the way that it's written in Shasta County is just significantly different enough than the way it was in an Orange County that a court would look at it differently and say, no, in the law world, shall is shall. It's not may, it's shall. When you say shall, it has to happen. So a plain reading of this section would say, you can't have a 1-issue charter. Now again, right now, I believe it would be legal. But again, as county council, I would say, you want to take into consideration not just what's going to happen today, but what's going to happen in 15 years. What's going to happen when we have different judges on the bench. What's going to happen when there's modifications to this. So again, this would be something I would explore deeply and make sure I had a very thorough research memo to my client about what a recommendation would be. Okay. So one of the other questions was, what happens after the vote is taken? So Measure D comes, it votes, if it passes, what happens next? So what happens next is that it goes to the Secretary of State. And the Secretary of State approves it. The Secretary of State does not have the ability to say, I don't like this. This doesn't work for me. It is a ministerial duty. They just take it, they stamp it, and it goes in the file. So it really is up to the electorate. And again, Eric said it correctly. Every change that's made to it has to go through the same process. Once you vote in a charter, you don't get to make free changes. You have to actually go through any small language change. You have to go through this process again. Okay, so that's my legal analysis on Tehama County and D, and happy to open it up for questions.
So that was pretty good. Do you feel better about what we know and what we don't know? Speaking of what we know, is we have an earring here, a very attractive earring. For those of you that have an attractive silver earring, it's right here. Oh, we have two different earrings. Oh, maybe it's the same one. I don't know. Anyway, we have a pair of earrings now. It's good for anyone. I have microphones for both of you, and I have me here. Questions way in the back. I actually recognize that man. Cork, would you like to ask a question?
Thank you very much, both of you. Very helpful information, very impressive.
Perhaps should we do this with a microphone?
Let me do it. I'll do it.
I don't know exactly how to turn the microphone on. Would you do that for us, Mike? Thank you. And then we will have a microphone, presumably on up here. Not that one. Oh, that one. We're ready. We have a microphone up here. Okay, go ahead, Cork.
Again, thank you very much for the presentation. It's very, very informative. So my question is, and this may have already been answered, but when was the last time that a governor appointed a supervisor replacement?
Do you know that?
I don't have a specific date, but I know it just happened, I believe, in Yolo County. Supervisor Sandy passed away, and I believe the governor appointed his spouse to fill his seat. That happened, I think, within the last.
I think I read that.
Now,
Yeah.
was that a county
2
request?
months. I don't know if the request came from the county or not.
Go ahead. Margaret has an answer.
Just to answer it, I represent 6 counties actually. I'm county council in 3. And
Your
then
microphone's not on.
I had it on.
I'll come up here.
Oh.
Hang on.
Come up here.
So I'm county council in 3, and then I have 3 additional ones. I can tell you the last time I've had a board member be appointed in one of my counties it's almost 10 years. It's been a while. It's been a long time. We did get the one in Trinity County back a while ago, and since then we haven't had any. Modoc County kept the vacancy open till election.
Frank?
The Kane County was ratified in 1916, and the legislature ratified it, in 1970. So does the legislature still have to ratify such? And if they, knowing the makeup of the legislature now, what if they don't ratify it? What would happen?
You want
Do you want to speak to?
No, go ahead. It's not anymore.
Okay, I don't know if this works. So, in my understanding, and Margaret might be able to speak more explicitly to this, I believe, speaking to the fact that when a charter is adopted, it becomes statute and is reflected in our state's laws. It's my understanding that that is a formal process. There's not, a legal review or that kind of thing. To the extent there is legal review, it would happen through the courts and, challenges to that charter's authority. But that, to my knowledge, does not happen with, ledge council or whomever it is that's responsible for taking that charter and putting it in our statutes. But, Margaret,
So I read that it takes effect the first of the following year.
yes.
Right. So January of 2025.
Correct.
That's correct. There's nothing that's done on a state level to approve or disapprove it. When it goes into effect, there's no way to challenge it at the state level. The only way to challenge it again is through the court process.
Question.
Who wrote this charter? Was there a charter commission?
In
Well,
Shasta County?
Technically, it was written by the Board of Supervisors, as it was an action by the Board of Supervisors that resulted in the ordinance that is now on the ballot.
So where's,
I think I left that on your table. There's a copy of it on your table.
where's the rest of it?
Where is the rest of it? The rest of what?
The charter that we can go read. Is there a place that they posted it?
So,
The whole charter?
yes, there's a copy on your tables if you want to look at it right now. But it is, one of the requirements is that they do have to do multiple publications in order to be effective. So it is available online. It's also available if you ask the county, they have an obligation to send it to you. You can PRA it and they'll send it to you. But there's a copy on the table.
Yes.
Could you speak to what ulterior motives the county might want to get chartered?
Susan, could you, for the sake of the camera, repeat the question back to me?
So the question on the table is, what ulterior motives might the Board of Supervisors have in asking for a charter?
From a legal perspective.
From a legal perspective.
Since it's a
Just
legal
to say it.
question, I'll give that
Good
one to Margaret.
So I think you're asking me to legally read people's minds? Is that the question? I don't know. Again, I don't know, and I don't have an opinion on that. I look at it from a legal perspective. There are charters that are good, and there are charters that are bad. So you'll have to decide for yourself whether you think this one is one or the other.
And remember that this charter will only have the one issue in it. And any other issue that someone might want has to come back to the voters, technically in a general election. Technically. Yes, over there? There was another question.
Next one's a Missy right there. Oh, sorry.
Oh, Missy, I'm sorry, you're right behind my computer here. Missy.
So as a hypothetical, we have our great, as you mentioned, county clerk, Kathy Darling Allen, who's in here. And if they have the charter passed, it sounds like they can kind of rearrange. She's not one of those protected asterisks like the sheriff. So they could potentially have to wait out her term and then appoint somebody they want as the county clerk.
So,
No. Go ahead.
yeah, exactly. There we go. So in order to make a position that's currently an elected position into an appointed position, you would either have to have voters approve that change through a charter or through local
A charter modification?
or a general law county. Exactly. So simply by adopting a charter, which is currently on the ballot, that alone will not give the Board of Supervisors that additional power. That would happen through an amendment through a charter, which would have to go through this same process that the adoption of the charter is going through. So it would have to go, be included in the board packet at a board meeting. The board decides if it's the board initiating the change. Would have to go. All the information would have to be public and would have to be voted on by electors in Shasta County.
Yes.
I was just curious if does the funding change from the state of California? Is there any money issues with going from a charter for services from the state?
No.
I don't believe so.
For a city charter, there would be, but as Eric nicely pointed out, city charters and county charters are very different. City charters, you can deal with minimum wage, you can deal with other funding sources, you can deal with prevailing wage. County charters, you can't. So there will be no money related except for your set compensation of your county officials, if you choose to put that in there.
Exactly. And for what it's worth, we spoke to the Shasta County Board of Supervisors, and then CSAC also spoke to the San Benito County Board of Supervisors who was also considering a charter in 2020. At the time, the San Benito County Board chose not to do it because of the cost of conducting an election. It's actually the opportunity cost, but adopting it, whether or not a county is a charter county, general law county, makes no difference in terms of appropriations from the state or any funding formulas.
Thank you. Way in the back first, and then Kim will come up to you.
This may have already been asked, but I'm going to ask it in a different way and hopefully get an answer. Do we know what problem Board of Supervisors was trying to solve by creating this charter?
I believe that we do. Do you like that just sort of general, passe thing. Well, the question is, if Kevin Cry is recalled and there's a vacancy on the board, who appoints the person to replace him on that board? And how are they replaced? And I have to say that I think that there are some people on the board who really don't want the person appointed by the governor of California. And so this is their probably violating the Brown Act as they do it, their solution to the problem.
Except that this doesn't go into effect until 2025.
Technically, it doesn't go into effect until 2025, and that's an issue for someone other than probably the three of us up here. Kim?
Yeah, I have a quick question because I'm a little confused about the timing of the election. So we're talking about this being in March, but then the language you had there said regular election, general election. So can you do it in a primary election? And isn't that by itself going to be suspect to litigation if it?
Maybe.
Yeah.
So they're just giving it a whirl.
So again, all I was trying to do is point out what I would look at, and that would be something that would raise a lot of concern for me as county council, because I spend a lot of time looking at what's a general election and what's a non-general election, because tax measures can only go on a general election. Certain things can go on special elect. And so that would be, I just was highlighting my kind of concept I was trying to say is that to create legislation on the fly is a horrible idea in general. And I mean this across the board. These things have long-term ramifications on your jurisdiction, and looking through each word and each letter to make sure that it means exactly what you intend it to mean is very important. And I would, if I was advising that board, said, hold please, do you really mean to put this here? Because here's what potentially could result.
Back in the middle table, or we left the middle table, and now we're going over to Cheryl McKinley.
Okay, so just to clarify, based on what you just said, there could be somebody could legally challenge the basis of this charter election because it's not being held during a general election. Is that correct?
I'm not here to give legal advice.
Okay, all right.
But I'm saying it's something to look into. It's something you always want to look into.
It's something that could happen.
Sure.
And general elections are held every 2 years in November. Is that correct?
The next one is November of this year.
No? Or is it only every 4 years?
No. No, they have a weird chart that the state puts out about when is a special. That's what I was saying. Every time, that's always the first thing my eye goes to when anyone's doing these types of things is, did you have it on the right election? The famous example is the city of Weed. They did a tax measure and they put it on a non-general election. They got all the votes, they passed the tax measure, and then it was overturned because of the fact it was on the wrong election. So as an attorney, first thing I always check is, are you on the right election?
So we're not sure exactly when all the general elections are.
I think we could say there's some question. It depends on if anybody challenges it.
So if the recall is successful and the charter is successful, there would be a supervisor election in November, would the board be able to still replace that supervisor even though it does not become effective until the 1st of January of next year? Or is that what you said we don't know the answer to?
You guys, it's different.
I believe they would not be able to use the additional powers under that charter until 2025, until January 1 of 2025.
And there's a general election between now and January of 2025. So that is a kind of a difficulty. You have a law that may not take effect till January of 2025, but we have a general election that someone could technically, I think, file to run in November of 2024.
I'd have to do the calculations on that.
Yeah.
I'm sure.
I'm just throwing out what it looks like.
It's usually you have to get 88 days prior and all that good stuff. So I actually don't know the answer to that, whether you'll get somebody on the November election.
Where's
or not.
Kathy?
But it's all in code about whether you can get somebody. It just has to give the election officials sufficient time to do all what they have to do. So it's typically, I believe it's 88 days prior. The vacancy has to occur 88 days prior.
Terry Applegate in the middle there.
When we have the next pandemic, when we have the next pandemic, does this give the Board of Supervisors power to ignore the state requirements?
No, not currently.
I don't believe it could ever, based on what the Constitution allows you to put in there.
No, I would echo the exact same comments. Just generally, no. Really, charters just give counties the authority to a little extra authority regarding home rule, but cannot use a charter to ignore state laws, state mandates.
And think back to the slides that they showed us. There are very specific things that they can address with their charter. Bruce Ross up. Oh wait. Okay, in the back. Hi, Jan.
Down here. I've been in a couple of meetings where there's been a lot of concern about this proposal. And one question that's come up 100% of the time is, are there counties that became charter counties and then later on went back to the voters and undid it, went back to general law? And if that has happened, would you please talk about it?
I didn't find any.
Well, it did not happen in its entirety, but it somewhat happened in Tehama County because they did go back in 1960 and take out most of their charter. They just left a few items in there. And I have seen situations where they have gone back and fixed it or removed sections that they had put in before. But no one has gone, as far as I know, no one has just done away with their charter and gone back to just a general law.
Yeah, I'm not.
Is there anything that's appropriate that
No. Yeah, the Constitution gives counties the authority to repeal a charter, of course, if approved by voters, but I'm not aware of any instances of that either.
Yeah, I kind of looked around for that because I thought it was an interesting factoid, but I didn't see it. Bruce, I think you're next.
So forgive me if this gets too deep into the weeds, but I believe one of the slides I saw said one of the things that a charter can do is create term limits for county board of supervisors. So separately, we will have a ballot measure establishing term limits in Shasta County on the March ballot that is not part of the charter. Does it make a difference whether it is part of the charter or not part of the charter?
It doesn't make a difference. The question, the next question, which I'm assuming is coming, was what happens if they both pass? Which one has the authority, and the charter would trump it. So if you have two, if you have one that's not through your charter and one through your charter?
It has the same effective law whether it's in the charter or not?
Correct. General law has the ability to set term limits, and charters have the ability to set term limits. So either way works.
And so term limits is Measure C on your ballot, in case you haven't looked at your ballot yet. Well, I don't think the ballots are out, but I'm just telling you that Measure C is on your ballot. And if you want to know more about Measure C, you can come visit with us at noon on the 31st of January at, where are we going to be? The library. Donnell.
I noticed on your slide that one of the options is for like the voters or citizens to put a measure on the ballot for a charter. What would it take for that to happen?
So that's a great question. It requires the citizens to create a charter commission. I believe it requires 15 members from the public. There's a lot in statute that prescribes how these commissions operate under. I believe they're subject to the Brown Act and have to abide by all of those laws and regulations. I think too that any charter commission that does not meet all of the criteria in statute obviously would not count and would not qualify for revising, amending a charter. But there's a number of steps that are prescribed within statute, thank you, regarding how a charter commission can be formed. But all that's to say, to put it more simply, yes, citizens can form a charter commission, put something on the ballot to amend adopt, repeal the charter. But it's a fairly complicated and involved process, but it's definitely an option for citizens to do.
I just want to point out we're close to past 7:30, and we're going to wrap it up. Anybody else have questions? I've got the microphone right here. Raise your hand. We want to hear from you.
Okay, so we have another opportunity to discuss this very thing. On January 31st at the library, we're going to discuss Measure C, Measure D, and Proposition 1, which is the conversion of the Mental Health Services Act to the Behavioral Health Services Act, attached to a bond of $6.4 billion to house people. So come and join us then. I think that we'll have a lot of information for you. And let's give these two a great hand. I mean, I think that we had great soup, but we really had better speakers. Thank you. Thank you. Thank you so much. Look forward to seeing you again.
This throughout the day, and then sometimes the band. Okay, well, thank you.